Today, our first webinar will be about international human rights law. So I'm going to talk to you, which I'm sure a lot of you already have some understanding of, about the 9 core human rights treaties and the International Bill of Rights, and then which ones apply in Kyrgyzstan. And then after me, you're going to hear about how these are incorporated into Kyrgyz law and some examples of that. And this first webinar is going to provide a foundation for our future webinars. Before going into human rights law itself, I wanted to briefly explain the United Nations and the different mechanisms within the UN structure. So the UN Charter has provided for 6 bodies, which you can see here. So this body in the dark purple is the Security Council, and the Security Council has primary responsibility for the maintenance of international peace and security. And it has 15 members, 5 which are permanent and 15 non-permanent. The next body in green is the General Assembly. It's the main deliberative, policy-making and representative organ of the UN. All 193 member states of the United Nations are represented in the General Assembly. And the Human Rights Council, of which Kyrgyzstan is currently a member, is part of the General Assembly. You can also see listed there some of the procedures of the Council, which I will talk about in our next webinar. The third body in orange is the Economic and Social Council. It's the principal body for coordination, policy review, policy dialogue, and recommendations on economic, social, and environmental issues, as well as implementation of agreed goals. So, for example, the Sustainable Development Goals. Bodies under this council include the Commission on the Status of Women and the Statistical Commission. This body has 54 members that are elected by the General Assembly. The body in blue is the Secretariat. This comprises the Secretary General, who is head of the United Nations, and tens of thousands of international United Nations staff who carry out the day-to-day work of the United Nations. And this includes the Office of the High Commissioner for Human Rights. Lastly, the lighter purple is the International Court of Justice, which is the principal judicial organ of the United Nations. This last body, the Trusteeship Council, provided supervision for 11 trust territories that were under the administration of other states. These 11 trust territories now all have their own government and are independent, so the Trusteeship Council has suspended its operations. And so it has that dotted line there, as it doesn't really exist anymore. So, United Nations human rights treaties are created through resolutions of the Human Rights Council, which is part of the General Assembly. The Office of the High Commissioner for Human Rights, which is part of the Secretariat, supports the drafting of these treaties and the work of treaty bodies. And in our next webinar, I'll go into much more detail about the work of the treaty bodies. So, turning to the treaties themselves, I'm going to start with what's called the International Bill of Rights. The International Bill of Rights consists of the Universal Declaration of Human Rights, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights, and its 2 optional protocols. And I'll explain these documents in much more detail.
The Universal Declaration of Human Rights is a miraculous text. At a time when the world emerged from cataclysmic events, the Declaration sets out universal rights and recognized the equal worth of every person. The Declaration, which was drafted by representatives from all over the world, embodies a common language of our shared humanity, a unifying force at the heart of which lies human dignity and the duty of care we owe each other as human beings. In the past 74 years, the importance of universal, indivisible, and inalienable rights has only become clearer. Yet, there is a growing disconnect between the standards on the one hand and the realities on the ground on the other. Even as the 30 articles of the Declaration have sparked transformation in all areas of our lives, the embers of racism, misogyny, inequality, and hatred continue to threaten our world. We face a triple planetary crisis and skyrocketing inequalities exacerbated by the COVID pandemic. And we are grappling with a rise in populist politics and authoritarianism, a deluge of misinformation both online and offline, and an alarming spread of conflict and violence. All of these factors are impeding our progress towards a freer and more equal world. In 2023, we will commemorate the 75th anniversary of the Universal Declaration of Human Rights. It is also the 30th anniversary of the Vienna Declaration and Programme of Action, which paved the way for the creation of my position, the United Nations High Commissioner for Human Rights, and my office. This coming anniversary year will be our opportunity to recall the consensus envisaged by the Declaration, to reset and to strengthen the remarkable human rights architecture that we have built over the years. With an eye to the past as well as to the future, I hope that the UDHR 75 initiative, which will be led by my office together with our partners, will allow us to rekindle the spirit, the impulse, the energy, and the vitality that led to the Declaration 75 years ago. The language and spirit of the Declaration have the potential to overcome division and polarization. It can make peace with nature, our planet, with each other, and point the way to sustainable development for future generations. The light of the Declaration can shine in the daily lives of individuals, in communities all over the world, in their neighborhoods, in schools, offices, and on the streets. But this requires our generation, including young people, to give the Declaration new life, to take ownership of it, and to repurpose it to meet the needs of our times and the challenges of our future. In 2023, I invite everyone all over the world to take up the torch for human rights and use these rights to forge a common future of dignity, freedom, and justice for all.
So the man in this video is Volker Turk, and he is the current High Commissioner for Human Rights. So as you saw in the previous slide, the Office of the High Commissioner for Human Rights is part of the UN Secretariat. This video was created to celebrate the 75th anniversary of the Universal Declaration of Human Rights, which will occur in a few months on the 10th of December this year. So the Universal Declaration of Human Rights is considered the foundational text of human rights. It is a milestone document for its use of universal language that doesn't make reference to a particular religion, political structure, or culture. It was a milestone in 1948 when it was created following the Second World War. World leaders had decided to complement the UN Charter with a roadmap to guarantee the rights of every individual everywhere. It was drafted by representatives with different legal and cultural backgrounds from all regions of the world who comprise the Commission on Human Rights. The document itself consists of 30 articles detailing an individual's basic rights and fundamental freedoms. These include to be free from torture, freedom of movement, freedom from discrimination, to be presumed innocent until proven guilty, freedom of religion, the right to work and the right to education, and the right to a remedy when rights are breached. It's been described as a common standard for achievement for all peoples and all nations. While it will be 75 this year, the rights are still very relevant for today's world. However, it is important to note that, as the name suggests, the Universal Declaration of Human Rights is only a declaration and therefore is not legally binding. This means that states are not legally required to uphold all the rights in this declaration. However, the rights within the Universal Declaration of Human Rights have been incorporated into subsequent international treaties, which are legally binding on states who ratify that treaty. So both the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights were based on the Universal Declaration of Human Rights. So following the Universal Declaration of Human Rights, from 1948 to 1966, the Commission on Human Rights task was to create a body of international human rights law that was based on the Declaration and to establish mechanisms needed to enforce its implementation and its use. So the Human Rights Commission produced two major documents, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, both of which entered into force in 1976. And I'm going to talk a bit more about now. The International Covenant on Civil and Political Rights, or ICCPR, aims to promote and protect human rights in the civil and political space. Some of the civil and political rights in the ICCPR include the right to life, the right to vote, the right to freedom of conscience and religion, the right to be free from torture, and the right to a fair trial. Most of these rights are not absolute. Instead, they are subject to reasonable limitations, which are created for a legitimate purpose. So, for example, it might be legitimate to limit a right in order to protect national security, public order, or the general welfare of a democratic society. If a right is limited, these rights must be prescribed in law. So, for example, the United Nations Human Rights Committee has held that restricting political polling imminently before an election in order to maintain the integrity of the electoral process is a reasonable limitation. And this was a case about Korea. However, there are some rights that are absolute and they can never be infringed. These are the right to life, the prohibition of torture and other cruel, inhuman, or degrading treatment or punishment, prohibition of slavery and servitude, the prohibition of imprisonment for inability to fulfill a contractual obligation, the prohibition against the retrospective operation of criminal laws, and the right to recognition of law. Human Rights Committee has continually said that even in situations of public emergency, these rights and provisions remain in force. The ICCPR has two optional protocols. The first optional protocol is the individual communications mechanism, which we will discuss in our next webinar. The second optional protocol concerns the abolition of the death penalty. It doesn't say you must not use the death penalty, but it commits states to take steps to abolish the death penalty. So that's a brief introduction to the ICCPR. It's the International Covenant on Economic, Social and Cultural Rights, or ICESCA. Rights under ICESCA include labour rights, rights to health, education, a family life, social security, to participate in cultural life, and to have an adequate standard of living. To fulfill these rights requires resources, particularly financial resources and also time. The concept of progressive realization recognizes this. So ISESCA states that parties must undertake steps to the maximum of its available resources with a view to achieving progressively the full realization of the rights recognized in the present covenant by all appropriate means. This means that states must do as best as they can to fulfill these rights within their available resources, and that they must get closer to fulfilling these rights over time. So, for example, Scotland has a Homelessness Act that aims to ensure that everyone is housed. It establishes different categories of priorities and aims to have everyone housed within 10 years, recognizing that everyone cannot be housed and their right to housing fulfilled immediately. So here again, on the left-hand side, you can see the International Bill of Rights, which was similar to slide 3. So the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. These covenants address rights for all people. There are also 7 subsequent conventions, and these conventions address either specific phenomena or minority groups. And I'm going to briefly discuss each treaty now. All of these conventions are legally binding. So once a state has ratified the treaty, they are legally bound by that. And we will discuss monitoring mechanisms on these treaties in our next. This specific phenomena treaty was the Convention on the Elimination of All Forms of Racial Discrimination, or CERD. It condemns racial discrimination and promotes understanding among all races. The idea of this treaty stemmed from African states newly emerging from colonial rule and then gaining UN membership. Mounting international concern over racial discrimination led the United Nations General Assembly to adopt this treaty in 1965. This is the definition of racial discrimination, which is defined as any distinction, exclusion, restriction, or preference based on race, color, descent, or national or ethnic origin, which has the purpose or effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing of human rights and fundamental freedoms in the political, economic, social, cultural, or any other field of public life, as you can see here. So CERD requires state parties to eliminate racial discrimination, including by condemning organizations that promote racial hatred, educating with a view to combating prejudices, and repealing laws that have the effect of creating or perpetuating racial discrimination. So, for example, the Committee on the Elimination of Racial Discrimination said that a grandstand of a football stadium that was given a name after someone, a prominent local sports person who was known by a derogatory term, they said that this should be renamed. And they noted that the convention is a living instrument and it must be applied in the circumstances of contemporary society. So perhaps back when the stadium was named, this derogatory term was more accepted, but the committee is saying now that it is no longer an acceptable term, therefore this stadium should be renamed. Moving on, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, or CAT. So the prohibition against torture is considered a principle of customary international law. This convention requires state parties to take measures to prevent torture, including the education of law enforcement and military personnel, banning the use of evidence obtained by torture, and establishing universal jurisdiction for cases of torture. This treaty was adopted in 1984 and entered into force in 1987. The call for a treaty about torture was made after an Amnesty International gathered reports from all over the world of people being tortured, and then they launched their first ever campaign against torture. And this campaign showed that torture was taking place around the world and there was a need for a treaty. So torture is defined as any act by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining from him or a third person information or a confession, punishing him for an act he or a third person has committed or is suspected of having committed, or intimidating or coercing him or a third person, or for any reason based on discrimination of any kind, when such pain or suffering is inflicted by, or at the instigation of, or with the consent or acquiescence of a public official or other person acting in an official capacity. So torture is stereotypically thought of as someone who has pervaded the political or public sphere and is interrogated. And this is true, it is torture. However, the definition of torture has also been found to encompass areas such as gender-based violence and abuse in healthcare. So in a general comment, the Committee Against Torture has said that states' due diligence obligations to prevent, investigate, prosecute, and punish acts of torture by non-state actors include looking for gender-based violence and issues such as rape, domestic violence, and trafficking. Moving on to the Convention for the Protection of All Persons from Enforced Disappearance. This convention makes it clear that enforced disappearance is a crime against humanity. It requires state parties to investigate acts of enforced disappearance and bring those responsible to justice, to establish jurisdiction over the offence of enforced disappearance when the alleged offender is within its territory, to cooperate with other states in ensuring that offenders are prosecuted or extradited, and to ensure that victims of enforced disappearance have a right to obtain reparation and compensation. It is a relatively new treaty, having been adopted in 2006 and coming into force in 2010. The adoption of this convention was prompted by advocacy of families of disappeared persons and NGOs from across the world, which emphasized the pressing need for a treaty to prevent and eradicate this practice. Enforced disappearance is commonly thought of in regards to dirty wars in Latin America, particularly Argentina and Chile in the 1970s and 80s, but it is a practice that happens across the world. This convention is heavily modeled on the Convention Against Torture. Enforced disappearance is defined as the arrest, detention, abduction, or any other form of deprivation of liberty by agents of the state or by persons or groups of persons acting with the authorization, support, or acquiescence of the state, followed by a refusal to acknowledge the deprivation of liberty or by concealment of the fate or whereabouts of the disappeared person, which place such a person outside the protection of the law. Unfortunately, NGOs have found that states most affected by recent cases of enforced disappearance and those that have the largest number of unresolved cases are not part of political life and representation. It was drafted in the 1970s following the emergence in the 1960s in many parts of the world of a new consciousness of the patterns of discrimination against women and a rise in the number of organizations committing to combating the effect of such discrimination. CEDAW was adopted in 1979 and entered into force in 1981. Discrimination against women is defined as the distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by a woman, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. CEDAW has had a great effect in many countries in the world. For example, after ratifying CEDAW, Turkey changed its laws to raise the marriageable age to 17, to allow women to keep their maiden names, to allow women to work outside the home and to keep their own wages without permission from their husbands. I'm going to discuss this treaty and other treaties that talk about gender equality much more in our future webinars, specifically on the topic of gender equality. Moving on to the Convention on the Rights of the Child, or CRC. CRC is the most widely ratified human rights treaty in history. It sets out the civil, political, economic, social, health, and cultural rights of children. 1979 was the International Year of the Child. There were reports of grave injustices suffered by children, such as a high infant mortality rate, deficient healthcare, and limited opportunities for basic education. There are also alarming accounts of children being abused and exploited in harmful jobs, of children in prison or in difficult circumstances, and children who were refugees and victims of armed conflict. It was therefore decided a specific convention for children was needed. CRC was adopted in 1989 and came into force in 1990. A child is defined as every human being below the age of 18 years, unless under the law applicable to the child, majority is attained earlier. There are 4 core principles within this treaty: non-discrimination, the best interests of the child, the right to survival and development, and lastly, to incorporate the views of the child. Moving on to the Convention on the Protection of the Rights of All Migrant Workers and Members of Their Family, or CMW. This convention emphasizes the link between migration and human rights. It recognizes that migrants are frequently exploited and that they face serious human rights violations, and that appropriate action should be encouraged to prevent and eliminate clandestine movements and trafficking in migrant workers, while at the same time ensuring the protection of their human rights. The convention was adopted in 1990. However, it didn't come into force until 2003, when it was ratified by 20 states. Countries that have ratified this convention are primarily countries of origin of migrants, and most countries who receive migrant workers have not signed this convention. A migrant worker is defined as a person who is to be engaged, is engaged, or has been engaged in a remunerated activity in a state of which he or she is not a national. The Convention doesn't create new rights, rather it reaffirms rights for migrants specifically, such as to be free from torture, to have freedom of thought, privacy, not to be subject to collective expulsion, to be able to express their culture, to have an interpreter in courts or tribunals, to be recognised as a person before the law, and to be treated no less favourably than nationals. Moving on to the Convention on the Rights of Persons with Disabilities, or CRPD. CRPD has been hailed for enabling a shift from viewing persons with disabilities as objects of charity, medical treatment, and social protection towards viewing them as full and equal members of society with human rights. This is the newest treaty. The drafting of this document involved people with disabilities and is the first treaty to benefit from the participation of its targeted stakeholders. It was adopted in 2006 and came into force in 2008. The definition of discrimination against someone with a disability is any distinction, exclusion, or restriction on the basis of disability, which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. It includes all forms of discrimination, including denial of reasonable accommodation. There are 8 broad principles within this convention, which are respect for inherent dignity, non-discrimination, full and effective participation and inclusion in society, respect for difference and acceptance of persons with disabilities as part of human diversity and humanity, equality of opportunity, accessibility, equality between men and women, and respect for the evolving capacities of children with disabilities and respect for the right of children with disabilities. This convention is the most quickly supported human rights instrument in history and gained strong support from states across the world. So this is the last of the and here is a summary showing all the treaties we have discussed. So this patch here of the 9 core human rights treaties which are legally binding, which I have discussed, and they are the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the Convention on the Elimination of All Forms of Racial Discrimination, the Convention Against Torture and Other Inhuman, Degrading Treatment or Punishment, the Convention for the Protection of All Persons from Enforced Disappearances, the Convention on the Elimination of Discrimination Against Women, the Convention on the Rights of the Child, the Convention on the Rights of Migrant Workers and their Families, and lastly, the Convention on the Rights of Persons with Disabilities. At the top, this document also shows the Universal Declaration of Human Rights, which is not legally binding, but provided a foundation for human rights treaties. If you would like to know more information about the specific treaties, the best place to start is with the treaty themselves. However, there are other places you can get more information. Firstly, general comment. So general comments are a treaty body's interpretation of a specific article within the treaty, and they will provide more in-depth information on this specific article. For example, you can see here the Committee on the Rights of the Child's general comment on Article 4, which is about measures to progress children's rights. This general comment provides more specific detail on how a state's budget should account for children's rights. And there are many more general comments of which you can find on the website of the Office of the High Commissioner for Human Rights. You can also look at the jurisprudence of the various committees. I'll go into more detail on the consideration of complaints in our next webinar, but for you to know that the committees issue findings on these complaints that they receive, and that you can then look up these complaints to help you decipher a treaty. And I've mentioned some of these complaints when I've discussed the treaties with you earlier. You can also look at concluding observations. So these are produced at the end of a review into the state's implementation of the treaty. And I'm going to talk more about this process in our next webinar. So you can find general comments and concluding observations and committee jurisprudence all on the website of the Office of the High Commissioner for Human Rights. Also, each treaty is available there. Each treaty body has its own page with links to the treaty, links to big decisions, links to concluding observations, and its general comments. So here you can find a list of the 9 treaties and whether Kyrgyzstan is a party to this treaty, which I'm sure a lot of you already know. But as a reminder, Kyrgyzstan is a party to the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Elimination of All Forms of Racial Discrimination, the Convention Against Torture and Other Inhuman, Degrading Treatment or Punishment, the Convention on the Elimination of Discrimination Against Women, the Convention on the Rights of the Child, the Convention on the Rights of Migrant Workers and their families, and the Convention on the Rights of Persons with Disabilities. So therefore, all these treaties are binding within Kyrgyzstan. Kyrgyzstan is not a party to the Convention for the Protection of All Persons from Enforced Disappearance, and therefore this treaty is not legally binding within Kyrgyzstan. So I'm just going to play a quick video which simply explains the principles behind a state's obligations under these treaties. Many of you might be familiar with these concepts, but this should provide a brief reminder.
States legally are the duty bearers when it comes to guaranteeing human rights. Concurrently, the state is the only actor who can legally violate human rights. When we talk about the state, this includes all state organs and representatives. For example, the judicial power, courts, judges, the legislative power, chambers of parliament, members of parliament, and the executive power, police forces, state ministries and ministers, military forces, state representatives on the local levels like mayors, as well as all persons who have been vested with state authority for certain tasks, for example, public administration. All acts or omissions by these organs in their official capacity are attributed to the state, making the state accountable for this conduct. Under human rights law, a state has obligations to set a framework for conduct that enables people's enjoyment of their rights. We differentiate negative obligations and positive obligations. Negative duties oblige the state to respect human rights, to not unduly interfere in human rights. An example would be the obligation of the state to refrain from torturing an individual, respecting the prohibition of torture and inhumane or degrading treatment or punishment. Positive duties oblige the state to protect human rights and to fulfill human rights. In both cases, the state needs to become active in order to live up to its human rights obligations. We talk about the obligation to protect when we refer to the obligation of a state to take necessary measures to prevent or redress human rights abuses by private actors, individuals, private businesses. That means when one private actor is negatively impacting the enjoyment of a human right by an individual. For example, the state has the obligation to intervene if the physical integrity of one person is threatened by another private person. In this case, this would probably be a police officer actively intervening and protecting the right to physical integrity of the person attacked. We talk about the obligation to fulfill when we refer to the obligation of a state to implement general and structural measures that are needed to realize human rights, to take positive action to facilitate the enjoyment of human rights. This includes, for example, the duty to establish a functioning court system that is able to guarantee the right to a fair trial, or the duty to adopt laws criminalizing theft, protecting the right to property against abuse by private persons, to establish an educational system that allows for the realization of the right to education, etc. Most rights entail negative as well as positive obligations.
So, to provide some further description of the video, the obligation to respect means that states must refrain from interfering with or curtailing the enjoyment of human rights. For example, they must not conduct unfair trials, they must not torture, and they must not stop people from expressing themselves. The obligation to protect requires states to protect individuals and groups against human rights abuses. This includes preventing and investigating punishment and redress. So, for example, a state can uphold the right to be free from discrimination by having anti-discrimination law, enforcing this law, and punishing those who break this law. The obligation to fulfill means that states must take positive action to facilitate the enjoyment of human rights. States must take appropriate legislative, administrative, budgetary, judicial, and other measures towards the full realization of rights. This is an obligation of result, meaning that states are responsible for the outcomes of their actions, not just their intentions. For example, regarding the right to education, states must provide ways and means for free and compulsory primary school education, including, for example, setting up enough schools and hiring enough teachers. Upholding a treaty requires refraining from interfering with the rights, preventing the rights from being violated, and taking action to facilitate the enjoyment of these rights. It requires all these three elements. That's the end of my presentation. Thank you very much for listening.